Another law that's been passed within the past 5 or 6 years is the Health Insurance Portability and Accountability Act, or HIPAA as it's commonly referred. One of the key provisions of that act is a provision that protects the privacy or confidentiality of patient medical records. Prior to HIPAA, it was much easier for employers and other entities to receive confidential information, medical information, from patients and even employees. What HIPAA does is it requires health insurance companies, health insurance plans, and administrators to seek narrowly drawn releases, seeking the information specifically that's required or that is being sought, and also seeking a narrowly drawn time limit for the information before providing that medical information to employers or other entities who are requesting it. One of the things that many employers and companies struggle with is the balance between caring for an employee who has a serious medical condition and HIPAA's privacy requirements. The important thing to remember there is if an employee or person with a serious health condition authorizes or introduces the subject of his or her serious medical condition, then the employee, out of caring and respect for the individual, can of course discuss that situation with the individual. Whether to discuss that situation with other colleagues of the individual, however, is another story. Even with a carefully drawn authorization from the individual or employee, an employer runs a risk of violating HIPAA if the employee shares personal details about the individual's medical condition with other employees. It is generally acceptable for the employer to, for example, request donations if other employees are interested in helping out with medical treatment or bills or food needs of a family. It is not generally acceptable, however, for the employer to tell other employees the specific nature of the condition. Even if an employee authorizes his or her employer to share details of the employee's serious medical condition with other employees, the employer runs a risk of violating HIPAA if it does so. An employer is better served in those cases by sharing only information with employees who have a need to know the other employee's specific condition, such as an individual in the benefits department of the employer or in the human resources department, or perhaps the employee's own supervisor. The problem you have in those situations is an employee who has a serious medical condition may say it's okay for the employer to notify employees without really thinking about the ramifications of that. And if you work at a place that has 250 employees, the employee may be thinking coworkers. They're going to share the information with my coworkers, when in reality, the employee doesn't want that information shared with someone in the intellectual property department, for example, or in the information technology department. HIPAA is broader than email or computers. However, in this technology age that we live in, people are sometimes much freer with information over emails, over the internet, even over the telephone, than they would be if they actually sent a letter to someone else. So many of the violations that we see with regard to HIPAA come from personal one-on-one conversations or email correspondence, as opposed to what we would consider medical records or draft documents. The ADA, the FMLA, any other state or federal laws only provide what we call a floor. It doesn't preclude an employer from providing more leave, for example, than the 12 weeks required by the FMLA. It doesn't preclude an employer from providing an accommodation to a disabled individual, even if that accommodation would not technically be deemed reasonable. So an employer can always go beyond what the law requires. For most employers, especially small employers, regardless of HIPAA, information about an employee's serious health condition is going to become known to other employees. Employers are like anybody else. They're small communities. Employees talk, and in most cases, the employee's concern about someone else's medical condition is purely that, just a concern for a friend. And in those cases, it is perfectly permissible for an employer to send out emails, notices, phone calls, things like that, allowing other employees to demonstrate their concern in various ways, by providing donations for medical bills, by providing food to the other family members of the employee, and whatever other ways the employees can suggest. Those things are not precluded by HIPAA. What is precluded by HIPAA is the employer sending out an email or other correspondence to employees, notifying those employees of the specific details of the medical condition that their coworker has. In a correspondence, such as an email from an employer to a group of employees about one of their coworkers who has a serious medical condition, the employer in such case, if the employee with the medical condition authorizes, may alert the other employees to the general nature of the medical condition that the employee has, such as the employee has a particular type of cancer, the employee has a particular type of diabetes or other condition. However, the employer should not, in those circumstances, give any indication in terms of the treatment or any other specific nature of the medical condition that has not been authorized by the employee. With the permission of the employee with a serious medical condition, an employer may subsequently update other employees on the coworker's condition. However, in doing so, an employer should be careful only to release the information that has been specifically authorized by the employee with the serious medical condition. In terms of patient rights concerning the confidentiality of medical records, patients, of course, have a right to view their own medical records. Additionally, health insurance companies and the actual treating physician may have a right to see the medical records of the patient with relation to the specific condition for which the patient is being treated. However, a patient has an absolute right to confidentiality of his or her medical records with respect to other individuals. One exception to this would be with regard to the patient's employer. If the patient is seeking some type of reasonable accommodation, such as leave from the employer, a change in a work schedule, or a change in work duties, then the employer may have a right to see the medical records of the patient solely related to the condition for which the patient is seeking an accommodation. The general rule for employers and employees is not to initiate conversations about health issues, but to respond to conversations initiated by the employee with the serious medical condition. It is polite and caring to respond to those conversations when they're initiated by the employee at issue. However, it is improper for the employer or another employee to initiate those conversations. The obligation is on the employee to notify the employer of any serious medical condition that might be affecting the employee's work. An employer, by law, is only supposed to consider whether the employee is satisfactorily performing his or her job. If the employee never tells the employer that he or she has a medical condition that might be affecting their work abilities, there is nothing the employer can do. If the employee believes that he or she has a medical condition that is affecting his or her ability to perform the job, the employee should notify the employer of that so that they can engage in a dialogue about whether a reasonable accommodation exists to assist the employee in performing his or her job. An employee has no obligation to share medical information with an employer if the employee does not believe that the medical condition is affecting his or her ability to perform the job. The converse of that, unfortunately, is that if an employee never tells the employer about the employee's medical condition, there is no obligation on the part of the employer to provide reasonable accommodation to the employee. There's a distinction between self-insured employers for health insurance purposes and employers who are not self-insured. They contract out to third-party health insurance companies. If an employer provides health insurance under a self-insured plan, such that it comes out of the pocket of the employer, then the benefits department and the administrator of that plan within the employer may see certain medical records that the employee would prefer the employer not know about. Under those circumstances, the administrator of that health insurance plan has an obligation not to share that information with the Human Resources Department or the supervisor of the employee. If, however, it is not a self-insured plan, then no one at the employer, either the Human Resources or the Benefits Department, should see the medical information relating to the employee unless the employee authorizes the release of information to the employer. There is a federal law that exists known as COBRA, which protects employees from losing their health insurance coverage after they leave a particular employment and under certain other circumstances. What that law provides is, once an employee loses his or her coverage under a group health insurance plan through divorce, disability, termination, or certain other qualified reasons, that employee is entitled to continue coverage for a period of 18, 29, or perhaps even 36 months at his or her own expense after the loss of coverage. This is designed to protect individuals during gaps in employment after termination from one employer and before they begin another employment, so that they will not lose coverage during that interim period.